Our instruments or commercial paper can be transferred by assignment and by negotiation. I've already introduced what an assignment is. Assignment is the transfer of rights under a contract. It's governed by contract law. Parties can intentionally create an assignment, but when a transfer fails to qualify as negotiation, it's going to become an assignment. The assignee is the one receiving the transfer, and they take subject to any defenses the transferor or the assigner has against them. Negotiation, on the other hand, is the transfer of a negotiable instrument to another in such form that the transferee becomes the holder. The holder receives the negotiable instrument. The holder is legally entitled to payment on it. A negotiable instrument is payable to that person, the one identified by name or bearer, and they receive the rights of the previous possessor. They may further qualify as a holder in due course, thereby obtaining even more rights than what the transferor had. There are two methods of negotiating. It depends on whether the instrument is an order instrument or a bearer instrument. When we have a bearer instrument, which we know is payable to any party, it says bearer, it doesn't need to be a name, it could be cash. It is negotiated by delivering that instrument to someone, and the holder of a bearer instrument only needs to possess it. That's it. They show it for payment, and that's all they need to do is possess it. They do not have to endorse or sign it or make a mark on it anywhere. So for example, a check made payable to cash or to bearer, they just bring it to the bank or the financial institution listed on it, and they can get paid. Obviously, we already talked about the risks. It could be lost, it could be stolen, and the possessor can do whatever they wish with it. The second method is the order instrument, a negotiable instrument payable to a specific person. It is negotiated or transferred by physically delivering the instrument, and we need an endorsement. So what is an endorsement? It's a signature placed on the instrument for purpose of transferring ownership rights in that instrument. So for example, if we have a paycheck that says pay to the order of Rebecca Fox, and I take it to the grocery store, I got to sign the back to get what the amount is on the front. Was it delivered? Yes, it was my paycheck. And now I'm endorsing it or signing it. What if I wanted to give that check to you? I would have to write on the back, usually on the back, pay to the order of your name, and then I sign it. And then in order for you to get the amount on what's stated there, say it's $2,000, in order for you to get the $2,000 that the check's amount is made out for, you have to endorse it. You would then have to sign your name after it. So you got delivery when I gave it to you, but then you'd have to endorse it if it's an order instrument. So let's talk about the various types of endorsements. We know that an endorsement is required whenever an instrument is an order instrument. Most often, it's written on the back of the instrument. The endorser transfers by signing and delivers. An endorsee is to whom the person is endorsed and delivered to. We also call that person the holder. So our types include a blank, a special, a qualified, and a restrictive. With a blank endorsement, it's merely signing the name, and what happens is it converts the order instrument into a bearer instrument, so anyone can then cash it. So for example, B endorses a check in blank that has been made payable to his order. He lost it, and C found it, who delivered it to D. Can D cash it or transfer it? Yes, D is a valid holder since C's endorsement is not required because it was converted to a bearer instrument. So if you got your paycheck and you just signed the back and then you drop it and you lose it, anybody can pick it up and then cash it. Special contains the signature of the endorser and identifies the person to whom the instrument is made payable to, and only this person can cash the check. So on the back of a check, I write pay to the order of you, or I can say pay to and your name, and then I sign. Now, if you sign at this point and lose it, it became a blank and anyone can cash it. So then you would have to write paid to the order of somebody else's name or take it right to the bank and cash it. Another example, a check made out to cash is delivered to CARP. And so now we know it's a bearer instrument because it's made out to cash. CARP writes on the back, paid to Don, and signs his name. Well, it was a bearer instrument. Now it's an order instrument. And now it requires Don's signature to either be transferred or to be redeemed or demanded payment on. The qualified endorsement. Generally, an endorser, upon signing, promises to pay the holder or any subsequent endorser the amount of the instrument if it's later dishonored. The qualified endorsement disclaims this liability, so the language is without recourse. Ann Knowles endorses the instrument without recourse and signs her name. This would relieve her of liability. So, for example, I write a check, pay to the order of you for $1,000 for the purchase of your used car, but you owe your rent, which is $1,000. You write on the back of the check, pay to the order of landlord, and you sign it and you give it to the landlord. If the check is later dishonored for insufficient funds, you'll be liable to the landlord for any fees and costs involved related to the check. You will also still owe the rent. If when you endorsed the check, you wrote the qualifying language without recourse, so you disclaimed any liability for the check, the landlord would have to come to me, the last endorser, for the fees and the money. Lastly, we have the restrictive endorsement. This requires the endorsee to comply with certain instructions regarding the funds involved, but does not prohibit further negotiation of the instrument. Sometimes, though, there are only one use when we have a restrictive endorsement, such as for deposit only. There's only one use there. The check can only be deposited into the pay's account. But other examples besides for deposit only, pay any bank. Pay Smith for Jones. An improper example would be pay to Smith if Smith washes cars, because remember, no conditions. Pay to Smith only is actually not a proper restrictive endorsement because this actually restricts the negotiability, because Smith can then not in turn use that for something else or transfer it for something else. So that wouldn't be allowed. We can also have combination endorsements, which we do, but we don't really think about it that way, because we can have a blank with a qualified. I have my paycheck and then I sign it, but I can also write without recourse on the end of that. So now I've had a blank and now it's qualified. I can write for deposit only without recourse and sign it. I can use any sort of combination of these endorsements.